You want me to call this one early? Can you find these people? That one. All right. Good morning, ladies and gentlemen. My name is Jennifer Hilal. I'm the county court judge presiding over today's hearings. You are here today. Today is not your trial day, nor is it the day to determine whether or not you're guilty or innocent. It's simply the day to determine whether or not probable cause exists for your arrest, and if probable cause does in fact exist, what a reasonable and applicable bond would be set at. You do have the right to remain silent. I caution you that everything you are saying is being recorded, so when you come up to the podium, please do not discuss the facts of your case. Additionally, you do have the right to have an attorney present. If you do have private counsel, when you come up to the podium, please let us know that you have private counsel. We'll do our best to reach that lawyer. Also, for those of you who do not have counsel today, the services of the Public Defender's Office will be appointed to you to be able to assist you throughout today's hearings. When I call your name, I'm going to read you the charges that you've been arrested for to determine whether or not probable cause has been met. Ask the state if they have a recommendation, if the defense has anything that they would like to present, and then we'll be setting bond. We are going to begin with, do we have this person yet?
Yes, it's towards the end.
Okay, so for Mr. Deputy, for Mr. Reed, we don't have the paperwork yet. I'm still waiting for it. So as soon as I do, I'll call him up, okay? Thank you. So we're going to begin with Ismar Rosario. Ismar Rosario? I have it on Main. I just don't see anybody there. I don't know if you do.
Are the speakers on? I don't know if they're hearing.
Speakers on now. Is Ismar Rosario present? Can they hear us? Oh, all right. Well, I have system on. I have speakers on. So let's see what's going on. I see myself on the back screen here. Yeah, let me see. Hold on. Let's see. Let me see if Paul Rain can hear me. Can Paul Rain hear me? Ma'am in the back row, can you see or hear me?
No.
No. All right. What's our IT?
7722.
77 who?
22.
Love covering magistrates.
Hello, you have reached JAF Help Desk.
Do we have anybody else? It's like Tom and I mean, what are their names?
Orlando? Who?
No, it's like Burger in them.
Craig Berger, yes. I don't have his number. Hold on. Let me look.
You just tried to call.
Sure.
7723. Can you have that?
Hi. 299? 2840. Craig's still right? He's still here?
He
Okay.
is
He's not
still
one
in
that
charge
retired,
of
right?
it.
Okay.
No, he has not retired.
Hello, you have reached the office of video op.
Jonathan. I think, Judge, like, you will have to select the jail, right? Let's
Yeah.
see if they can hear you like this.
Just say hello.
Hello? What's his name?
Rosario. Isamar Rosario.
Isamar Rosario? Isamar Rosario.
Hello? Hi, Craig. This is Judge Hilal. I'm trying to, I'm in magistrates and we can't seem to get any of the systems working. Do you know who I can contact? Perfect. Thank you so much. Bye-bye. They're gonna send Jonathan over, so hopefully we'll get up and running. Do we have any private lawyers that Good morning. We're not on yet, but if you tell me which cases you all are here on, I'll pull your cases to the front.
Just so you know, the case I'm here on has actually been a medical reset
Okay.
that yesterday shouldn't have really been reset because the client is 8.5 months pregnant. She was back from the hospital yesterday, and for some reason, it got pushed aside as a med reset, but she was at North Broward waiting to be called for magistrates.
Okay.
It's Ayana Tommy, and I have the PC here. It was put in the med reset bin.
Let me see if we can find her.
She's not on the docket this
Oh,
morning.
she's not. Okay.
No, but the problem is, I needed to address it today at some point, and I was hoping this morning, because it's a pretty dire situation. She's very far along in her pregnancy.
If you can get all the paperwork for me, I'd be more than happy to hear it. Otherwise, we could hear it this afternoon. I don't know if you've noticed we're having a whole breakdown here. We just got all the paperwork a couple hours late, and then the system's not working.
She has no priors. This is a misdemeanor battery.
Let the state just take a look at
Yeah.
it, and then as long as they're
Is it a domestic?
good with everything,
Your Honor, they're gonna have to go in front of Judge McHugh. It's a domestic,
okay.
so.
Well, we're actually going there now, but will she hear this?
That I don't know, but she handles the domestic first appearance.
She's the domestic judge, so if you head over there, just let her know the situation and ask her if she'll hear it. If she won't, then come back and let me know.
All right. we'll do
Okay?
that.
Thank you. Any other private lawyers here on any cases that they want me to pull out of order? Okay.
Okay, so we have all.
And sir, as soon as I have the paperwork on the case that you asked about, I'll pull it up, okay?
He is,
So that was him.
okay, and this one is Samuel Reed, right?
He is on Samuel Reed,
Okay.
but that one we don't have the paperwork on yet.
Let me check towards the end of this stage. May I?
Yeah. And then we have Ann Turnbull. Who's here for Ann Turnbull? You're on that one? Okay. That one I think I do have the paperwork on.
So we're looking for Turnbull now. Turnbull?
Yeah. So we'll pull Turnbull toward the front.
Okay.
Thanks.
Reed, I could not find Reed. You're saying we don't have Reed. So I think that is-
Just reset in front of Judge McHugh.
Okay, yes, we did. Can you try calling again?
He said he would. See, I can see myself up there. You seeing the
Yeah, I
screen
see
up there?
it. Mhm.
I'm gonna try not to. 'Cause I We'll turn it off while we're waiting.
No, probably gonna be asking 5,000.
I mean, I can see myself, but
I'll tell you what. Considering
main jail hear me? Can anyone at main jail hear me? Paul Ryan, can you hear me? Ma'am, at Paul Ryan, can you hear me? She shake her head yes?
Yes, she did.
Is there a deputy at Paul Ryan? Because when I said, can you hear me, she nodded her head, but I don't know if she's nodding in answer to a question. Yeah, okay. Conti, can you hear me? North Broward, can you hear me? No. Nobody for anywhere.
Yeah, I mean, it almost sounded like she heard you, but there's nobody around there.
Well, there has to be a deputy there, and she was talking to someone. So, main jail, can you hear me? Is there a deputy at main jail? No, none of them could hear me. I'm showing up on the live feed, but I'm not showing up in the jails.
On the call. Well, they say that I'm
Craig's out
showing
of coverage.
they're seeing you or not seeing you.
They told.
Megan Dolan, Thomas Megan Dolan.
Phone there.
That's what I was searching on.
Craig, do you want me to leave the live feed on?
If you would.
Okay,
Yeah, because that's the only way we can test it.
understood.
Megan's the first name, Ed.
Thomas.
No, Megan. Yes. She's there.
Okay, yeah, okay, fine.
It's only 9:45. Quick.
So we're good, right? Besides those we.
Yeah. Mr. Blank, you have one you want me to call out of order? Sure, our system's down, so we're delayed. Turn it on and off? Sure.
Who is it?
Can Main Jail hear me? Is there a deputy at Main Jail that can hear me? No. Can the Main Jail hear me? Deputy at Main Jail? No.
They want to get here. order? Thank you. But so I'm confused. We have Geva Vasquez twice.
Yeah, it's not looking good.
Yeah, we're not on, hold on, we're just waiting for it to come back, we'll switch it over. Yeah.
Geva Vasquez. Yes.
2015 should have. I don't know if you were.
Oh, I see. No, we did have that. We just don't have the BSO thing. The BSO report. So I guess there is no
I'm
file.
subconscious.
Which
Yeah.
was?
What do you mean?
What do you think?
You mean the probable cause affidavit?
Yes.
No, I need a probable cause affidavit.
Yeah,
Wonderful.
do
All right, so our system is just,
straight to pretrial.
the interface is still
I mean,
loaded,
I
so
think-
I can't flip from jail to jail yet, so.
Okay, got it.
I know.
Okay, got it. Thank
Right?
you.
I would be willing to do. I usually go higher,
Okay.
but I'd be willing to
We're
do
good. Thanks.
in exchange for pretrial with random testing, no driving, no further order of the court. I do an even $5,000 bond. Do 4, count 2, which is ROR 3.
Now
All right,
let's
wonderful.
give it a try now, Judge.
All right.
Let's see if we
Can the main jail hear me?
Where's this going?
Yes, Judge, good morning.
Wonderful, thank you. Good morning, and for everybody at all the different jails, I do apologize for the delay this morning. We've just been having some technical difficulties, but it seems that everything's been resolved. Good morning, my name is Jennifer Hilal. I'm the county court judge that's presiding over today's hearing. Today is not your trial, nor is it the day to determine whether or not you are guilty or not guilty. Today is simply the date to determine whether or not probable cause exists for your arrest, and if probable cause does in fact exist, what a reasonable and applicable bond should be set at. You do have the right to remain silent. Everything you are saying here today can be is being recorded, and can be used against you in future proceedings. So please do not discuss the facts of your case when you come up to the podium. When you're speaking with your lawyer, please make sure that the button is muted so it is not relayed over the system. Also, if you have a private attorney, please let us know when you come up to the podium that you do have private counsel. We'll do our best to get in touch with that lawyer and have them appear here today for you. If you do not have a private lawyer and you wish the services of the Public Defender's Office, they will be appointed today to help you throughout these proceedings. When I call your name, I'm going to read the charges you've been charged with, let you know whether or not probable cause exists, and also let you know what the bond will be set at, what state's position is, as well as defenses. So we're going to get started with, it looks like Samuel Reed. And Mr. Reed is,
He's approaching, Judge.
thank you so much, at the main jail. Can you check him off the docket? He was out a little. All right, Mr. Reed, you have been charged with 2 counts of aggravated assault with a deadly weapon without intent to kill. The court does find probable cause exists. State, do you have a position on this case?
Yes, Your Honor, Mr. Reed has no history. That being said, I'm going to be requesting a $5,000 bond on count 1, $2,500 bond on count 2. No victim contact, no possession of any firearms, weapons, or ammunition. My concerns are allegedly he threatened both roommates with a BB gun and did in fact, according to his statement and the victims, did in fact threaten to shoot both of them.
Okay. Defense?
Judge, as you heard correctly, my understanding, Mr. Reed has no prior contact with the criminal justice system. He's been living in our community his whole entire life. He is a registered voter, has very strong ties to the community, has his family, graduated from local Dillard High School. Judge, he's looking forward to having his day in court and contesting specific issues within the probable cause affidavit as far as the allegation is concerned. He is working. He basically is supporting his girlfriend and his 2 children. He has 2 jobs, one at the Family Dollar, where he gets paid about $9 an hour, and he just obtained his second employment with a company that installs solar panels that he hasn't even gotten paid his first week yet at work. He's going to be relying purely on his girlfriend to help post his monetary bond. My understanding is, I believe his family has reached out to a bondsman, but from my understanding, their financial resources are quite limited. So I'm asking you to take that into account in determining reasonable release conditions and a reasonable bond for Mr. Reed.
Okay. I believe there is a witness here, ma'am. Do you wish to be heard?
His girlfriend.
You're his girlfriend? Okay,
Yes.
so you're just here for support. Sir,
Yes.
is there anything that you wanted to say on the
Yes,
record?
I'm the bondsman. I also spoke with his father, Samuel, who's going to try to support and bond him out, and he is limited on funds. The most he said that he can pay is $2,500 per count.
Okay. Based on the allegations that are within the probable cause affidavit, as far as him making statements, I'm going to catch 25 to life, threatening the people inside with what appeared to be a gun. Court's going to issue bond at $5,000 on count 1, $5,000 on count 2. No victim contact, no weapons of any kind. Thank you, sir. Good luck to you. Thank you so much.
If I may,
Yes, sir.
the family, I wasn't able to sign her in because she just came in. The mother for Naomi Penna, page 5.
Okay, give me one moment and I have a couple that
All right.
signed in before and then I'll call her, okay?
Thank you.
Thank you so much. Ian Turnbull?
He's here, Judge. Do you have a page?
Do you have a page on? Page 7.
Found it. Thank
Sorry,
you.
there were a few that signed in out of order. All right, Mr. Turnbull, you have been arrested for 1 count of domestic battery by strangulation. Let me look at my notes. Court did find probable cause exists. State?
Your Honor, I'm going to be requesting a $15,000 bond, no victim contact, pretrial release of the GPS monitor. Mr. Turnbull was arrested in 2015 for a domestic violence battery against a different alleged victim that was dropped. My greater concern is the allegations in this case and noting that the victim's 1-year-old daughter was present at the time of the alleged incident.
Okay, defense?
Judge, that's $15,000 is going to be something out of reach for Mr. Turnbull. My understanding, Judge, in speaking with Mr. Turnbull, at most, we were going to be requesting a $3,500 bond. Now, he will be abiding by the court's order as far as no contact with the alleged victim. Him and the alleged victim do live separate and apart. He's right now living with his aunt in Miami. My understanding, Judge, is Mr. Turnbull is working right now. He works part-time whenever he's given hours for a local moving company, and he only gets paid about $10 an hour. So that is why we're requesting a $3,500 bond on Mr. Turnbull's behalf. Yeah. And Judge, he also has other expenses, child support, supporting his children.
Okay. Sir?
We've had him on bond before. I'm the bondsman.
Okay.
And we're willing to take him on bond again. He's followed the rules in the past with us on bond. So we're just here to support him and let you know that we're willing to take responsibility for him while he's out on bond.
Okay. I do share the same concerns as the state. I mean, the allegations are that he had his 1-year-old child in his mother's arms at the time that he was choking her. So court is going to impose the $15,000 bond requested from the state, as well as no victim contact, pretrial with electronic monitor. Good luck to you, sir. Isaiah Thompson. And what page is Mr. Thompson on? There's another out of order. Let's see. I think it was 15 or 13, maybe. 13, thank you. I'm page 13, everyone. Hi, Mr. Thompson. Good morning, sir. Sir,
How you doing, ma'am?
I'm good, thank you. You've been charged with 1 count of possession of a weapon or ammunition by a convicted felon, as well as 1 count of violation of probation or community control under case number 15-5023 CF10A, as well as case number 15-012092 CF10A. Counts 2 and 3, the violation of probation. You are currently being held no bond. You will have a hearing in front of your assigned judge. Do we have a hearing date for him yet? On October 20th.
Tomorrow at 8:30.
Perfect, so tomorrow at 8:30. As far as the firearm by convicted felon, court does find probable cause exists. State, what's your recommendation?
1 moment, Your Honor.
Sure. Oh, what is today? Sorry. The 21st.
And Judge, while the state is looking, considering as a no bond hold, he's going to have to go in front of his division judge to seek some sort of relief. We're going to be requesting $1,000 on his behalf.
Your Honor, considering one of the cases he's on probation for is home invasion, robbery with a firearm, or deadly weapon, state would be requesting a $7,500 bond on count 1.
Mr. Ramirez, I mean, that is concerning. He's on probation for 2 felonies, one of which is a home invasion, so Court's going to impose the $7,500 bond. No weapons, obviously, sir, as well. I'm going to put as there as a condition. McFarland. Good luck, sir. Tadell McFarland.
He's here, present, Judge, in Maine.
Great, thank you. And I believe that's also page, is that
Pardon, it's
13.
page 13.
page
yes.
13. All right, Mr. McFarland. Yes, ma'am?
I couldn't talk on his behalf on Mr. Thompson, the guy that was just there.
Mr. Thompson?
Yes.
Can you call back up Mr. Thompson if he's still there? I didn't realize he had someone here on his behalf. Yes, ma'am. What is your name?
I mean, my name is Bonnie Canino. I own a boxing gym in Dania Beach, Florida. And this guy is not a criminal. He's a young guy. He just turned 22 on his birthday. We just got him a good job. He's starting in 2 weeks, doing the drawbridge. I mean, this guy takes 2 buses, come train at the boxing gym. He works with kids all the time. He's not a criminal. I think, you know, he was just out on his birthday. Maybe a car got pulled over, something happened. But this guy is a wonderful guy. I mean, we're going to put this guy in trouble when he was just getting out of trouble, I guess, you know, making himself better. And we put a lot of time into him, and he's really a great guy.
I appreciate your kind words on his behalf, ma'am, and I'm sure he does as well. That's something that you can bring up in front of the division judge because he is being held no bonds because he does have those violations of probation. The allegations here are that he was found with a silver revolver. So that's going to be up to the court. So you can speak with him and you could be present at all of those hearings, but for purposes of probable cause, the court does find that it exists and another judge is already holding him no bond. Well, right now he's held no bond, but he's going to appear in front of his division judge tomorrow. Okay? Thank you so much for being here on his behalf. Tadell McFarland, also page 13. Hi, Mr. McFarland. Good morning, sir. Sir, you're currently being held no bond under case number 15-000-928-CF-10A, a violation of probation, as well as case number 15-004-206-CF-10A, another violation of probation. Do we have his VOP hearing date?
It's supposed to be tomorrow.
My docket's just not marked, so I just want to notify him of when his hearings are.
It's going to be the 22nd.
Okay, so sir, your hearing will be tomorrow at October 22nd, okay? Thank you. Good luck.
Say that too. No, this one's not sent because it's on the...
Naomi Pena,
Page 5.
page 5.
North Broward, Judge.
Great, thank you. All right, good morning, Miss Pena. Miss Pena, you've been charged with 1 count of burglary with a battery. After reviewing the probable cause affidavit, the court does find probable cause exists, that proof evident presumption great. Does state wish to be heard and does defense wish to be heard?
Your Honor, the court having made a finding of proof evident presumption great, I would ask that Ms. Pena be held no bond so the state, if the defense can seek an Arthur hearing if they so choose. I would ask the court not to exercise discretion. I believe the victim should have an opportunity to address the court if they so choose. And my concern in this case is that Ms. Pena did not break into the home once but twice.
Understood. Defense? Anything that you
Yes,
submitted?
Judge, we would object to the court making a finding of proof evident presumption great at this stage of the proceedings. I believe she has a bondsman and family members here in her support this morning. My understanding is that proof evident presumption great is the highest standard of proof that we have in the criminal justice system. The state has introduced no evidence. They've called no witnesses. And while the case law does say that the court may make a finding of proof evident presumption great based solely on a probable cause affidavit written by an officer who did not witness the events, it doesn't say the court must make that finding. I would ask the court to consider the fact that Ms. Pena, who has never been arrested before, not be held without bond. I would ask the court to set bond for her. First, we're going to argue that there is no proof evident presumption great, that the state has failed to meet that standard. In the alternative, if over our objection the court does find that proof evident presumption great has been found, we'd encourage the court to exercise its discretion and set bond for Ms. Pena in this case.
And also, there are 2 parties here on her behalf. Do you all wish to say anything? Good morning.
I'll take care of her and she won't do this again. She is disabled and I don't like to see her in there and I know she's, suffering in there. Is there anything we could work out?
Okay. Sir? You're the bondsman on this case as well? Okay.
Like I explained to the mom, there's a possibility, but we're requesting that the court does set a bond for her, as well as some type of pretrial, that she does live, the family lives close to each other, about two blocks near each other, so she would have support where she won't go around the victim anymore.
Okay. Again, I understand, Mr. Reedy, your objections, but the court is going to find proof evident presumption great based on the two different witnesses' accounts of the attacks as well as the two different break-ins into the home. Court is going to find proof evident presumption great and is going to be holding you no bonds, ma'am. That does not preclude you from having a full-blown Arthur hearing in front of your assigned division judge. When you get in front of your assigned division judge, you can have a further hearing in which your defense will be able to present defenses and mitigating circumstances on your behalf. I wish you the best of luck. Thank you all so much for being here. Have a great day. Mr. Blank, you're here on Perez?
Number 3.
Okay, great. Page 3. Good morning, how are you?
Entering a temporary appearance on behalf of Ms. Perez. I'm well, thank you. Good
Okay.
to see you as always.
Good to see you as well.
Judge, a couple of things
Sure.
preliminarily. First, we would be stipulating, well, I guess I should wait for Ms. Perez to get on camera.
We are Miss Perez, Diane Perez. She's at North Broward?
Yes.
Oh, there you are. Okay, hi, Miss Perez. How are you, ma'am?
Fine.
All right, Miss Perez, you've been charged with one count of DUI above a 1.5, as well as DUI third offense within 10 years, as well as driving license suspended as a habitual. The court has reviewed the probable cause affidavit. I do find probable cause exists. However, you do have your attorney here on your behalf, Mr. Blank. Mr. Blank, do you wish to be heard?
Yes, Judge, a few things. First of all, we would invoke my client's right to remain silent at this time. Additionally, Judge, after speaking with the state prior to approaching the court on this matter, we have come to an agreement on bond.
Okay.
And the agreement, correct me if I'm wrong, but I'm going to try to get it right, is $1,000 on count 1, $4,000 on count 2, ROR count 3. Defendant would be released to pretrial with random testing at her expense and no further driving without further order of the court. Did I get it perfect?
Mr. Blank's got it perfect.
There you go.
Are you putting her on a scram or no? Is that still, I don't know if that's.
No, these were the
Tag?
conditions.
Okay.
Yeah, no.
I don't know the lingo now.
No, Judge,
No,
it was
these were the
random testing.
conditions.
Just
that
random testing?
Yeah, and no driving until further order of the court.
Okay. Okay, so Ms. Perez, you understand it's going to be a $1,000 bond on count 1, $4,000 bond on count 2. Count 3 will be ROR. You're going to be assigned to pretrial with random testing at your expense. No driving, no alcohol, no intoxicants. You understand?
I understand.
All right, have a wonderful day, ma'am. Good luck to you.
Thank you very much, Your Honor.
Thank you. Have a nice day. Okay, we're back to the regular order of the docket. We have Isma Rosario. Isma Rosario.
Main jail.
Thank you.
I'm sorry, Judge, I didn't hear you.
Sure. It's Ismar Rosario.
Rosario is here present. Come on up, ma'am. She's here at Maine.
Okay. Hi, Miss Rosario. How are you, ma'am?
I'm doing pretty good, ma'am. How are you?
I'm good. Thank you for asking. Miss Rosario, you've been charged with one count of aggravated assault with a deadly weapon, as well as one count of domestic battery by strangulation. Court has reviewed the probable cause affidavit, does find that probable cause exists. State what's your position.
Your Honor, the state would be requesting a $5,000 bond on count 1, $7,500 bond on count 2, no victim contact. Ms. Rosario's criminal history includes out of Seminole County theft in 2015 and 2014. In 2009, out of both Osceola and Orange County, she was sentenced to 4 years state prison for trafficking stolen property, burglary of an occupied dwelling, burglary of a structure, and multiple other counts of trafficking stolen property. Nothing further, Judge.
Okay.
Judge, unfortunately, that bond amount is not something Ms. Rosario is going to be able to afford. My understanding is she's working at the Cheesecake Factory. She's been there 8 months, making approximately $16 an hour. Now, she is living in a park. She's living in Miramar, where her monthly rent is approximately $850. At most, Judge, she's going to be able to afford is about $1,000 on each count. So that is why that is why we're asking for that monetary amount, Judge.
Okay. Mr. Rosario, the probable cause affidavit is concerning the allegations are of choking your girlfriend as well as holding a knife to her throat. So based on the allegations that are contained therein, the court's going to be setting a bond of $5,000 on count one, $7,500 on count two. No contact whatsoever with the victim, direct or indirect. So that means no emails, text messages, phone calls, anything of that nature, okay? Good luck to you, ma'am.
Your Honor, our Creole interpreter is present.
Wonderful, thank you. Do we have anybody that needs a Creole interpreter at Main Jail?
Yes, Judge. The gentleman's name is, what page is he? Is Mr. Augustine, and he is on page 10. Hold on 1 moment, Judge. Come on over here. On page 10 of the court docket. So halfway in your paperwork, probably.
Perfect, thank you. Found him. Okay. Thank you, raise your right hand. Swear or affirm the translation you're about to give is true and correct translation from Creole to English, English to Creole.
Yes.
Thank you, or I'm sorry, English to Creole, Creole to English. Thank you. All right, and state your name for me.
Jacques Bayardel, Bayardelle.
Thank you so much. Good morning, Mr. Augustin.
Bonjour, Monsieur Augustin.
Mr. Augustin, you have been arrested for one count of DUI.
Monsieur Augustin, il y a arrêté pour one count de DUI, étape conduite pendant intoxiqué avec alcool.
The court does find probable cause exists for the arrest.
Court l'a trouvé, c'est qu'il faut pas avoir cause, c'est-à-dire c'est exact pour arrêter, qui est arrêté.
State any reason why I should not impose the $500 bond.
Aucune raison, pas pour $500 bonne.
Your Honor, I wasn't going to be requesting any modification, but
Il n'y a pas d'argent pour les modifications.
but depending on what Mr. Romero requests, I may be amenable to agreeing to
Cependant, ça, Monsieur Romero demandé la connaissance d'affaires.
Judge, what I was going to be requesting is if the court would consider releasing Mr. Augustine on pretrial release.
Est-ce que tu as même connaissé quand on a plagué avec avant trial et puis on l'a gueule?
And I have no objection to that. I would just request no alcohol or intoxicants and random testing.
Pas d'objection pour ça, mais tu même connaître que il va boire aucun alcool ou intoxicant.
Any
No
priors?
objection to that.
Est-ce que tu as un autre problème avant ça?
Resisting with violence, but that was about 20 years ago.
Okay. All right. So the court is going to release you to pretrial release, sir. There's going to be no alcohol,
Il y a plago, ça le pre-trial release, faut pas boire aucun alcool.
no intoxicants,
Faut pas boire aucun intoxicant, aucun drogue.
random drug and alcohol testing,
Il y a checké de temps en temps pour alcool ou bien drogue.
and no driving.
Il faut pas qu'il doit conduire.
Good luck to you, sir.
Your Honor?
Yes, sir.
Just so he's clear, no driving, is that without unless he gets a hardship license?
Of course.
Yeah.
Unless you get a hardship, sir, which you can apply for through
À moins
DMV.
que ou bien ça relève un hardship license, son licence spéciale qui permet de conduire pour le travail seulement.
And I'll put on here no driving without hardship, so it's clear.
Donc, juge l'a mettait que ou ka conduire, mais faut pas conduire avec driving.
Judge, and I just want to explain to Mr. Augustine what happened with the services of the interpreter.
Sure.
On dit ça peut arriver avec service interpréteur.
Mr. Augustine, the court has agreed to let you go under the supervision of pretrial.
Le court là permet de aller avec supervision pre-trial.
I just gave you the location, the map, how to get to their offices.
Moi montre qui gens pour aller dans officio.
You're going to have to report today if you get out early enough and they're open. Do you understand?
Faut aller jeudi et si yo la go assez bonne, aller jeudi à patane.
If they're closed by the time you get out today, you must report there tomorrow morning. Do you understand?
Si yo fermé, tant yo la pour la go jeudi demain bonheur faut aller là.
If you don't report, there will be a warrant issued for your arrest. Do you
Si vous
understand?
parlez, il y a mettre warrant pour arrêter, vous comprenez?
Yeah.
Yes.
That's all.
All right.
Thank you, sir. Good luck.
My pleasure.
Thank you. Just can you say for one more second? I just want to make sure no one else needs Creole. Does anyone else at Main Jail need Creole?
No one else at main jail, Judge.
Okay. Can you make one more announcement for Paul Rain, Conti, and North Broward?
Est-ce que aucun monde besoin de qui parle créole?
Conti, no, Your Honor.
Thank you.
No problem. Good job.
Wonderful. Thank you.
Est-ce que aucun monde besoin de qui parle créole?
Perfect. Thank you so much, sir. Have a wonderful day. Appreciate it. All right, Utavia Brazil. Thank you. Hi, Miss Brazil. Good morning, Miss Brazil. Miss Brazil, you've been arrested for one count of aggravated battery with a deadly weapon. Court does find probable cause exists for the arrest. State, what is your position?
Your Honor, I'm going to be requesting a $2,500 bond and no victim contact. Ms. Brazil does have somewhat recent arrests for domestic violence. 2018, she was arrested for an aggravated battery with a deadly weapon that was dropped. 2014, out of Volusia County, misdemeanor battery that was dropped. She pled out a theft in 2019 and 2007. That being said, I am taking into consideration what the alleged weapon was in this matter, and that is why I'm requesting that bond amount with no victim contact.
Judge, I'm going to ask the court to consider pretrial release for Ms. Brazil. Yes, she does have some prior contact with the criminal justice system. As the state pointed out, a lot of those charges ended up being dropped. She has been a resident of South Florida for her entire life. She's been living at the same location for the last 7 months. It's her own place. She has provided me with the name and number of her mother, who I will call after court to see if there's any money available to post a monetary bond. But my understanding is that Ms. Brazil is not in a position to post a monetary bond. She does understand that she cannot have any contact with this alleged victim in the case, and they do not live together, so that will not be a problem for her. So I'd ask the court to consider pretrial release for Ms. Brazil.
State.
Your Honor, again, considering that within the past year she was arrested for a separate aggravated battery, even though it was dropped, obviously pursuant to state statute, that is something that I have to present to the court, and I think it should be considered. I think the $2,500 bond is reasonable.
And I agree with Mr. Lender. It is something that the statute does require him to bring to the court's attention, but he has not brought to the court's attention why it was dropped. And it's kind of left that up for speculation. Maybe Mr. Lender doesn't know. I don't know. Perhaps the victim didn't want to cooperate. I don't know what the circumstances were, but the fact is the case was dropped. Ms. Brazil was not. That was the state attorney's office decision to drop that charge.
Court will set bond at $2,000. No victim contact. The allegations in this case were caught via video from the victim, from what I read. So there's going to be no victim. Sure, ma'am. I would just caution you not to discuss any of the facts.
Don't talk about the facts of the case, Ms. Brazil. I will be calling your mother after court. And did you injure your hand during this incident?
Yeah, he broke my
Okay,
thumb,
all right.
and he messed up my whole mouth. I can't even talk, so
Okay,
that's why
we're
I
going to
defended
send somebody to
myself.
take photographs of you, all right?
They already have photographs.
Well, we're going to take our own photographs.
Do you want a photo order, Mr. Reedy?
Yeah,
Okay.
I'll draft
Perfect.
the order, Judge.
All right,
Thank
so
you.
your lawyer's going to have someone come take photographs of you in the jail so they could document your injuries. Court is setting bond at $2,000, and there is to be no victim contact. Good luck to you, ma'am. Have a nice day. Natasha Stewart.
No problem.
Thank you.
Yes.
Good morning, ma'am. Ma'am, you've been arrested for one count of resisting an officer without violence, as well as one count of petty theft. State.
Your Honor, the mental health specialist at the jail at North Broward Bureau has sent a recommendation referring Ms. Stewart to Judge Lerner Wren's mental health court.
Okay. So as far as bonds, how do you?
Oh, Judge Lerner Wren has previously sent a memo asking that on any cases that get transferred to her division, that the bonds be just be kept in place.
Okay, so leave it at $100.
That's what I do.
Okay, any issue with that, Mr. Reedy?
Well, I know she'd like to resolve it, Judge. And I know that in the past we've had these recommendations. I don't know who's making these recommendations or what their background is or what qualifications they have to make a determination that someone should be sent to mental health court. My conversation with Ms. Stewart, I didn't sense anything to cause me any concern about her mental state of mind. She did indicate that she would like to resolve the case today if possible.
Court. Evelyn Zamora with the Department of Detention and Community Programs with BSO. She is a licensed mental health counselor. That's who's making the referral, and obviously it's someone that Judge Lerner Wren relies upon.
Okay, I mean, what is your position with her resolving it today?
Your Honor, based on the referral, I am not in a position to make an offer at this time.
Which doesn't prevent the court from doing so.
I mean, I'll just be honest with you both. I don't know how you all handle these with Judge Lorena Wren. I mean, if there's an issue with potential competence as far as taking a plea. I mean, that's the only concern that I have.
I can only say that based on my conversation with Ms. Stewart this morning, there was nothing about our conversation that caused me any concern. Ms. Stewart, how are you feeling this morning?
I'm feeling great actually about the incidents that happened. I would like to resolve it. I really want to do pretrial or something. I don't care. I just want to get out of jail and resolve everything because it was very. It was.
Okay, what the
All
state's asking for, you'd be getting out of jail. It's a $100 bond is what they're requesting, just to transfer your case to Judge Lorena Wren's division so you could be able to look into your case a little further and not have it on your record.
No, I don't want mental health. I don't need any mental health services, period.
Okay, I'm going to put you on a brief recall, so Mr. Linder, you can let me know what basis we have to be sending her to mental health court.
Well, Your Honor, I can tell you, it is the referral from this woman that is a licensed mental health counselor. With all due respect to Mr. Reedy, who's saying, well, he doesn't know what basis this woman has. He certainly doesn't have any license. He's not licensed to make that determination yet. He's saying, based on his phone call, that she can take a plea.
But I'm saying is the basis of the referral, it's someone who met with her this morning?
Yes.
Okay, I mean, I just don't know how it
Oh,
works.
I
That's why I'm
apologize,
asking.
Your Honor. Yes, no. My understanding is there's, I can call Ms. Zamora if you'd like. My understanding is there's an interview with all these people. They, it's not just, people picked at random. But if you'd like, I can call Ms. Zamora if you'd like more details.
So, Ms. Stewart, I mean, at this point in time, I'd be transferring you to mental health unless you would like me to look into that further. I'd be more than happy to put you on a recall, and I can call you back at the end of the docket to be able to make that determination.
Well, I'm not gonna say I won't comply. I will comply, but I'm telling you, it will be crazy because I don't need mental health services. I have a 4.0 GPA. I left out of school.
So, do you want me to put you on a recall for the end of the docket?
Sure, yes.
Okay, so I'm going to put you on a recall, okay, just so we could find that out further. Thank you, ma'am. We have Albert Lovelace, page 7. Great, thank you. All right, Mr. Lovelace, you've been charged with 1 count of aggravated assault with a deadly weapon without intent to kill, 1 count of robbery firearm, 1 count of battery, ability to cause harm, and 1 count of aggravated assault with a deadly weapon. Court does find probable cause exists for count 1 and count 4. I'm failing to understand the probable cause on counts 2 and 3. If someone could point me to the direction of where anything about a robbery is discussed.
There should be a second probable cause affidavit, Judge.
I don't have that.
All right, if I may approach.
Please. The probable cause affidavit I have is from.
If you keep going, it's not there.
This is all I have. This is a copy of this.
Oh.
Thanks. Thank you so much. Okay, based on the additional probable cause affidavit that was authored by Jessica Castellan-Stand, court does find probable cause exists for counts 2 and 3 as well. The robbery firearm count, ma'am, are you here to testify? Or just here on his behalf as support?
Yes.
Okay, is there anything that you wish to say?
I mean, did they find a gun or anything about a robbery?
The allegations are that a gun was used, yes.
I wasn't aware of that.
Okay. Court does find probable cause exists. Court does find proof evident presumption great as far as count 2 goes. State, do you wish to be heard?
Your Honor, as far as the robbery firearm, the state would be asking that the court not exercise its discretion in setting a bond. I'm very concerned, as you can see, that there are allegations that the day after the alleged robbery that Mr. Lovelace committed violence against his victim again. Additionally, Mr. Lovelace in 2016 was arrested for sexual battery and felony battery, domestic violence by strangulation,
I'm sorry, you said when?
domestic violence battery by strangulation, and sexual battery against the same alleged victim. Those charges were dropped.
That was when, I'm sorry, though?
2016, I'm
Thank
sorry.
you. That's okay.
Your Honor, in addition to the robbery firearm, I'm going to be requesting a $10,000 bond on count 1, $2,500 bond on count 3, and a $10,000 bond on count 4.
And we would object to the court making any finding of proof evident presumption grade absent the showing of more evidence by the state, who has introduced nothing to support their contention that they have met the highest burden of proof that we have in our criminal justice system. They've called no witnesses, introduced no evidence, relying on a report written by someone who didn't witness the events themselves. That's woefully insufficient, certainly when we're talking about proof evident presumption grade. So we would ask the court not to make that finding and to set a bond for Mr. Lovelace here this morning.
Okay. Based on the allegations that are contained within the probable cause affidavit, court is going to find proof evident presumption grade. Will set bond at $10,000 for count 1. Count 2 will be a no bond hold. Count 3 will be $2,500. Count 4 will be $10,000. There's to be no contact with the victim, sir. That's direct or indirect, meaning no phone calls, emails, text messages, calls from the jails, anything like that. Good luck to you and have a wonderful day. Sure. Thank you all so much for being here.
Your Honor, we can go back to that other case. I don't remember her.
Miss Stewart?
Yes.
Okay. Natasha Stewart, I believe she was in North Broward. Okay, thanks. Miss Stewart. Okay, Mr. Linder? Who do you need?
The last,
Oh, sorry. Thanks. I apologize. Okay, so Mr. Linder, what did we find out about Miss Stewart?
Your Honor, I don't have an issue with the court. Actually, I'm going to make an offer because my understanding is the referral has nothing to do with competency concerns. And as Ms. Stewart has already stated, she doesn't want to go to the program. And as the
Okay.
court's aware, it's a voluntary.
Understood.
So it's really just, we'd be wasting our time sending her there.
Okay.
Your Honor, one moment. Let me see if she has a prior theft. Yes, Your Honor, she does have prior thefts. The state's offered being adjudication time served on both counts.
Is that what you'd like to do, Ms. Stewart? Adjudication time served?
Yes.
All right.
Okay, so raise your right hand for me. Do you swear affirm to tell the truth, whole truth, nothing but the truth, so help you God?
Yes.
Please state your name for the record.
Natasha Stewart.
And how old are you, Miss Stewart?
33.
How far did you go in school?
4.0 GPA in cosmetology school.
Are you currently under the influence of any alcohol, drugs, or medication that could affect the way you're thinking here today?
No.
Ever been treated for a mental illness?
Yes, and I don't have a mental illness.
Okay, anything about that treatment that prevents you from understanding what's happening here today in court?
No.
Are you currently being medicated for that illness?
No.
Are you currently receiving treatment?
No.
Okay. Are you under the influence of any type of alcohol, drugs, or medication that could affect the way you're thinking here today?
No.
Do you understand what's going on today?
Yes.
All right, and you understand you've been charged with 1 count of resisting without violence, which is a first-degree misdemeanor punishable by a maximum of 364 days in the Broward County Jail. State's offer to resolve the case is an adjudication, court costs, and time served. Is that your understanding?
Yes.
All right, and on count 2, it's a petty theft. With this charge, if you have 2 convictions and you were to pick up another petty theft, the court could actually charge you with a felony. Do you understand that?
Yes.
Knowing this, it's my understanding that you do have prior petty theft convictions, so chances are, if you were to pick up another petty theft, state could charge you with a felony. Do you understand that?
Yes.
And knowing that, do you still wish to go forward with this plea?
Yes.
All right, and you understand that is a charge that's punishable by an adjudication, court cost, maximum of 60 days, Broward County Jail, and again, state's offering adjudication, court cost, time served. Do you understand?
Yes.
All right, and has anyone forced you into entering into this plea?
No.
Has anyone promised you anything to have you enter into this plea?
No.
You understand by entering into this plea, you're giving up certain constitutional rights, such as the right to remain silent, the right to have the state prove beyond and to the exclusion of every reasonable doubt your guilt in this case, the right to present certain defenses, cross-examine witnesses, things of that nature, have a trial in this case. You understand?
Yes.
All right, and knowing that you're giving up these rights, how do you wish to plead? Guilty or no contest?
No contest.
I'm going to accept your no contest plea, and I'm going to adjudicate you guilty, sentence you to an adjudication and court costs on counts 1 and count 2. You'll have 6 months to pay court costs. Please make sure that you pay them. Otherwise, the clerk does actually suspend your driver's license, okay?
Yes.
All right, have a wonderful day. Good luck to you, ma'am.
Thank you.
Thank you.
Good luck.
Thank you.
Where do I fill out, is there a disposition sheet that I could fill out for her? Or do I just put on here adjudication court costs? Okay. Okay, thank you. All right, Paula Karras.
Bonded, Judge.
Okay. Erica Sims.
Present, Judge of Maine.
All right, good morning, Miss Sims.
Morning.
Miss Sims, it looks like you're being held on case number 19-025241 TC20A on a $1,000 bond. Case number 19-017835 TC30A on a $100 bond. Case number 19-030132 TC30A on a $100 bond. And case number 19-030132 TC30A on a $100 bond. Have a good day, ma'am. Good luck to you. Do we have Heather Firsch?
All right.
Thank you. Hi, Miss Hirsch. How are you, ma'am?
Good. Good morning, Honor. How are you?
I'm good, thank you. What did you say, Mr. Reedy? Oh, okay. State which, do you have any recommendation for her resolving this case? It's a petty
Yes,
theft.
just one moment, Your Honor.
Sure. Ma'am, it's my understanding that you want to resolve the case here today. Is that correct?
That's right.
Okay, just give us one moment, please, so I can let you know what the state's offer would be and
Thank you.
if court is in the same position. Thank you.
I don't see any prior thefts. The offer to be a withholding court costs.
Okay, so ma'am, it'd be a withholding court cost. Is that what you wish to do?
What is that? Can you just explain that to me?
Sure, it means that it's going to show up on your record. It's not going to be a conviction, but it is going to show that you pled to the charges. If you do have two of these, even if it's a withheld of adjudication, if you were to pick up a third, they actually could charge you with a felony.
Okay.
Okay, do you wish to resolve the case? Otherwise, it would just be a $100 bond, and then you could resolve it in front of the division judge on tomorrow.
Yeah, I just want it resolved today.
Okay, so raise your right hand. Raise your right hand for me. Do you swear affirm to tell the truth, whole truth, nothing but the truth, so help you God?
I do.
Put your hand down. State your name for me.
Heather Firsch,
All right, and how old are you, ma'am?
37,
How far did you go in school?
11th grade.
Do you read and understand the English language?
Yes.
Currently under the influence of any alcohol, drugs, medication that could affect the way you're thinking here today?
No.
Ever been treated for mental illness?
No.
You understand you've been charged with one count of petty theft, which is... Is this a second or a first?
I'm checking that right now, Judge.
Thank you.
This was a second.
Which is a second-degree misdemeanor punishable by a maximum of 60 days Broward County Jail. State's offer to resolve the case here today is a withheld of adjudication and court costs. Is that your understanding?
Yeah. Where's the second one? I didn't know there was a second one.
No, it's a second-degree misdemeanor.
Oh, okay.
Is that your understanding?
Yes.
Anyone
Yes.
forced you into entering into this plea?
No.
And you understand by entering into this plea, you're giving up certain constitutional rights, such as the right to remain silent, the right to have the state prove beyond and to the exclusion of every reasonable doubt your guilt in this case, right to cross-examine, call witnesses of your own if you so choose, right to have a jury trial. Knowing all of this, do you still wish to go forward with this plea, giving up those rights?
Yeah. Yes.
Okay. All right, court is going to accept your plea of a plea, guilty or no contest? Guilty means, yes, I did it. No contest means I'm not necessarily admitting guilt. However, I believe it's in my best interest to resolve the case here today.
No contest.
I'm going to accept your no contest plea. I'm going to sentence you to a withheld of adjudication and court costs. Court costs must be paid in 6 months, and I believe they're $293, if I remember correctly, okay?
Okay.
Have a wonderful day.
Thank
Good
you.
luck. Thank you.
Thanks, you too.
Thanks.
All right,
Okay.
good luck, Heather.
Kayla Garcia. Bonded? Thank you.
Judge, you see her name?
Oh, Kayla Garcia's there?
I think you already posted bond.
Okay, so we're being told that she's already posted.
Beautiful. Thank you, Judge.
Thank you. Good luck, ma'am. Tamoya Phillips.
She bonded.
Thank you. Lanisha Bullard.
No problem, no.
Thank you. Hi, Miss Bullard. How are you, ma'am?
I'm good, Your Honor.
All right, Miss Bullard, you've been charged with 1 count of grand theft auto, 1 count of possession of a controlled substance without a prescription, and 1 count of drug paraphernalia. Court does find probable cause exists for the charges. State.
One moment, Judge.
Sure. And it looks like she was a medical reset.
Yes. I'm not seeking any kind of bond increase, Judge.
Okay.
Judge, I'd be asking the court to consider pretrial release for Miss Bullard. She's been a resident here of Florida all of her life. She works as a chef. She's had that job on and off since 2008.
I just started back on the 16th.
She just started back, but she had been working there before. She does not have money to post a monetary bond, so I would ask the court to consider pretrial release for her.
Any prior
Yes, Your Honor. Ms. Bullard had a grand theft earlier this year. She was placed on probation. She violated her probation, was sentenced to 180 days county jail. She was just released from county jail October 11th of this year.
Oh, exactly. I just got out.
Okay. Based on that, Mr. Reedy, I'm not going to release her on pretrial.
Well, she's not going to be able to post a monetary bond, Judge. Would you consider reducing the bonds on count 1 and 2?
Mr. Linder, you have a strong objection?
Your Honor, I don't have an objection to a bond reduction on 2, count 1, considering that it's related to the offense she just got out on a week prior to this arrest that has to the state 1,000. And I have no objection to an ROR in 3 either.
Okay, so court will reduce count 2 to a $100 bond, and count 1 will remain at the suggested $1,000 bond, and count 3 ROR.
All right, thank you, Judge.
Okay, thank
I
you.
will call,
Good luck,
I'll make
ma'am.
that call for you, Lanisha, to see if we can get you out of there, okay?
Thank you so much.
Thank you, good luck. All right, Jomar Reyes. Jomar Reyes.
Judge,
I'm sorry, miss. Sorry?
medical loan.
Oh, thank you.
Your Honor?
Yes.
He's got an out-of-state hold. I would ask that the court be inclined to make a PC determination. That way, when he comes back, they can bring him directly before Judge Malika for his extradition hearing.
Mr. Mayor, any objection to that?
Actually, Your Honor, I don't believe the public defender represents
Oh,
out-of-state holds.
thank you, sorry. Hold on. Okay, so court does find probable cause exists for the out-of-state hold. He'll be set in front of Judge Malika when then?
It depends what.
Okay. Okay, but it will be,
Oh, yeah, she has extradition hearings every Tuesday and Thursday, I believe.
okay.
So it'll be whatever, depending on when he gets out, one of those
Okay.
days. Yeah, there's 3 seconds left.
Skoglin, Eric Skoglin.
North Broward?
Thank you.
Mr. Scoldman refused to attend, Your Honor. Good morning.
Good morning, how are you, sir? All right. So, refused, so,
Your Honor, I can tell you generally Judge Powell's policy is if there's a refusal, to give him 1 more day to
Okay.
come back.
so we'll reset it for tomorrow?
That's fine.
Thank you. Nanda Jagidis? Sorry.
He's out of medical loan.
Yes.
Thank you. Adam Zayas?
Zions refused to attend also, Your
Now,
Honor.
Your Honor, my understanding is, and Deputy, correct me if I'm wrong, he's been refusing since, I think, last Thursday.
Yes, sir, he has.
Your Honor, he's got a $10,000 bond on a strangulation and no bond VOP holds. I was gonna be requesting a $1,500 bond on this count. He doesn't need to be here for a no contact order because he already has a no contact order attached to the strangulation charge. This was just added to the strangulation charge.
Yeah, I don't have a problem with that.
Okay, give me just 1 second. So he's already being held no bond.
Yes, ma'am.
On counts 1 through 3?
No, on count 1, the strangulation, he has a $10,000 bond.
So which count is he being held no bond, just so I can mark it on here?
2 and 3.
2 through 3. 1 equals 10,000. And you're asking for
1,500.
1,500, and you have no objection, Mr. Reedy? Okay. All right, court's gonna impose a $1,500 bond, and obviously, no victim contact. Okay, thank you. Cameron Mascolo. Do we have Cameron
Bonded,
Mascolo?
Judge.
Thank you. Sukarat?
I believe North Broward.
Thank you. Do we have Abdul Wahab
Ma'am, he's here.
Surakat? Hi, sir. How are
Yeah.
you?
I'm doing okay.
All right. Good morning. You're currently being held on case number 17-007008 MM10A. Case number 17-007008 MM10A. It looks like all 5 counts are for the same case number, and there has been a bond set at $50 on each count. So that's a total of $250, sir. Good luck.
Yeah, and Your Honor, these cases are before Judge Lerner Wren, and that's where.
Okay, so you're already set in front of Lerner Wren, and you have a status, it looks like, tomorrow at 9?
Perfect.
Perfect. All right, good luck to you, sir.
All right.
Thank you. That one I actually had the note of. Thank you. Elijah Brown.
North Broward, and he would like to resolve this case. today.
Your Honor.
Okay. Hi, Mr. Brown. How are you, sir?
Blessed, ma'am.
All right, so, Mr. Linder, do you have a recommendation on Mr. Brown's case?
Your Honor, well, first off, I can't make an offer because of the nature of the offense, and I imagine there'd be restitution. I can also tell the court he has been referred for mental health court, and he's gone before Judge Lerner Wren in the past as well.
Okay.
So I'd be requesting that this be transferred to Judge Lerner Wren.
All right, so Mr. Brown, this is a victim case, meaning the victim does have the right to be heard, and it's my understanding there hasn't been contact with the victim yet to be able to make an offer. So I can transfer your case to Judge Lerner Wren. It sounds as though you've appeared in front of her in the past, and then you can resolve the case there. Do you wish to do that?
Yes, ma'am.
Okay, so we're going to transfer to Judge Lerner Wren, okay? And I am going to find probable cause exists. Good luck to you.
Okay.
Gilbert Hinton.
He's approaching Judge. He's here at Maine.
Thank you.
Municipal ordinance case.
Oh, okay. So Mr. Shate was here. Let me put you on a recall, Mr. Hinton, because Mr. Shate was here and he did say that he believed you wanted to resolve this case. Is that correct?
Yes, ma'am.
Okay, so let me put you on a recall, and as soon as I have him back here, then we'll proceed. Okay? Thank you.
Brief recall, sir.
Travis Telfair.
Yes, he'd like
Thank
to
you.
resolve this case if possible, Your Honor.
Is this also a city case or no? No? Okay. Yes. Okay.
Well,
Do
not
you know if that's on
necessarily. It might be
You know if
what
it's
you
on
ask
felony?
for.
What is he on pretrial for?
It's actually burglary of a dwelling with assault and aggravated assault. So with the PBL, Your Honor, I don't have an offer on the misdemeanor.
Okay, so you said he's currently out on pretrial release on that case, correct? Okay. So there's no need for the court to revoke, because I would normally revoke bond on that. No need to do that. Okay, so Mr. Telfair, there's already been a warrant signed because it looks like you violated the terms of your pretrial release on case number 18-011750CF10A. I would normally revoke bond with the new trespass that you have picked up. However, it's my understanding that a no bond warrant has already been signed on that case, so I'm not in a position to resolve this case here today. You will be seeing your division judge assigned to that felony probably sometime this week, okay, sir? Good luck to you. And I do find probable cause exists for the trespass. Okay, thank you. Scott Comator.
Bonded.
Bonded, thank you. Joseph Garcia.
He's approaching Judge here at Maine.
Thank
Come on
you.
up, sir.
Hi, Mr. Garcia. All right, Mr. Garcia, you're currently being held on a bond of $1,000 on case number 19-043750-TC20A. So bond has been set in the amount of $1,000. Good luck, sir.
Judge, Mr. Garcia is requesting if the court would consider an ROR on his behalf. Please.
Not by a bond that's already been set by another judge. I'm not going to. There's a KPS and that judge has already signed it for $1,000, so I'm not going to change it. Good luck to you, sir. David Garasinichuk?
No problem, John.
Thank you.
No, just stick it.
Okay. All right, sir, I apologize. I'm gonna put you on a brief recall just because I need to get the city attorney back here. He should be back in a few moments, and as soon as he is, I'll call you back up. Thank you, sir. James Ferrace?
He's approaching Judge. He's here at Maine.
Thank you.
And Judge, he's declined the services of public defender. He intends on hiring his own private counsel.
Okay, so sir, are you certain that you don't want the service of the public defender for today's hearing? You could always hire private counsel later, but they could assist you for purposes of today's hearing if you wish.
Sure.
So yes, you would like their services for today? Okay, so Mr. Romero, do you want a moment to speak with him?
Sorry? We're ready to proceed, Judge.
Okay. All right, so Mr. Ferrace, you've been charged with one count of disorderly conduct, a second count of disorderly conduct, and then it looks like,
Yeah, charged with count per call.
I saw that, 90 counts of misuse of a 911 system. Court did review the probable cause affidavit. Court does find probable cause exists for the arrest. State, what is your recommendation as it relates to bond?
Your Honor, I just spoke to Mr. Reedy. While there hasn't been a referral, Your Honor, based on the nature of these charges and the specific allegations, I'm also going to be requesting that Mr. Ferrace be transferred to Judge Lerner Wren.
So when it's transferred to Judge Lerner Wren, just so I understand, what happens with bond?
She has asked that whatever the bonds are, that they remain in place.
Okay.
You know, obviously, if there's anything aggravating, the court can take that into consideration. What happens is I will text Judge Lerner Wren's JA to let her know all the cases we're transferring so that she can schedule them to go, those defendants to go before Judge Lerner Wren as quickly as possible, at which point Judge Lerner Wren will take everything into consideration, whether, you know, does she need to refer them to receive treatment or address the bond or just resolve the matter.
Okay. So Mr. Ferrace, do you wish to do that?
No, opt out.
So Mr. Linder, he doesn't.
If he doesn't want to go, he doesn't want to go. I mean,
So what's your recommendation as it relates to bond?
I would ask that, one moment, Judge.
Sure. Okay, thank you.
Your Honor, I'm going to be asking for a bond increase on count 3 to $500. Mr. Ferrace has been convicted
Right, I saw that.
3 times, yeah. I can tell you right now, one time he pled out before Judge Pohl, and as condition of his county reporting probation, Judge Pohl ordered that he may not misuse the 911 system, that he cannot contact the Broward County State Attorney's Office or Judge Pohl's office either, just based on the fact that Judge Pohl felt the need to make that conditions of his probation. And these allegations gives me a cause for some concern. Obviously, I'd ask an additional condition of his release be that he not call 911 unless for anything other than legitimate reasons. Yeah, I know.
Okay, so you're asking for a $500 bond.
Yes, ma'am.
And Judge, Mr. Ferris is requesting the court keep the standard bond in place of $100.
Okay. Mr. Ferris, it does concern me that there's 90 counts of the identical charge in addition that you have previously been convicted of this same charge. So court is going to impose a $500 bond and also make as a condition of that $500 bond that there is to be no use of the 911 system unless it's an actual emergency. Good luck to you, sir. Ellis, David Ellis.
Mr. Ellis is here present, Judge Amain. Come on up, sir.
Come on up, Mr. Ellis.
Good morning, Your Honor. How you doing?
I'm good, thank you. Good, thank you. Okay, so, all right, Mr. Linder, on this one, this was another one, I didn't have a probable cause attached. Do you have one or am I missing something?
I do, Your Honor. One
Okay.
moment.
Give me one moment, Mr. Ellis, because when I received the paperwork, I didn't have all of it.
Just a note also, Your Honor, on your findings, it may show 2 counts of burglary. The state actually filed them as attempted burglary.
Okay, thank you. Thank you so much, appreciate it. Give me just one moment, sir.
Who's this? What's your hand?
Okay, based on review of the probable cause affidavit, court is gonna find probable cause exists for the 2 counts of attempted burglary.
I'm sorry, it's actually 1 count attempt, 1 count.
One count of attempted, okay. So of the 1 count of attempted and 1 count of burglary. State, what's your recommendation?
One moment, Judge. See if he's got anything out of county. Ellis. Your Honor, I'm going to be requesting $5,000 per count. In addition to these charges, Mr. Ellis in 2013 was convicted of grand theft. He violated probation, was sentenced to 17 and a half months state prison. 07 burglary of a conveyance, grand theft, 52 months state prison. 07 burglary of a conveyance, 53 months state prison. 06 armed burglary of a conveyance, grand theft firearm, VOP, 53 months state prison.
Okay. Mr. Romero?
Judge, I'm going to be asking for the court to consider a $1,000 bond on count 1 and a $2,000 bond on count 2. I do understand Mr. Ellis has prior contact with the criminal justice system, but my understanding, Judge, things right now are going well. He got a job. He's working at the Bonefish Grill. He's a server. He makes approximately $5 plus tip. He's been residing in our community his whole entire life. He's 34 years old. Now, he is living with his mother. My understanding is that's the only person that he can reach out to help post his monetary bond, and she works. She's a caretaker, so her financial resources are limited. Now, my understanding, this is not in custody capias. I believe the date of incident is not recent. It was, I believe, a couple months ago. But since these couple months, that's when he's gotten employment. He's been doing well. He's been going to court, Judge. My understanding, he will be coming to court to face these allegations. He is not a flight risk, Judge, so that is why we're asking for a $1,000 bond on count 1, on a $2,000 bond on count 2 on both these third-degree felonies.
When was he released from prison?
Late May of 2018.
Okay. Court's gonna set bond at $5,000 on count 1, $5,000 on count 2, seeing that he was just released from prison last year and has been sentenced to prison on multiple different occasions for the same allegations. Thank you, sir. Good luck to you. Thank you. Jarquan Braun.
I'm sorry, Judge, who did you call?
Oh, I'm sorry. I believe the last name is Braun. Braun. Oh, I'm sorry, Brown. It's.
Oh,
We have them
Bond.
handwritten, so I'm. Some of the writing I'm not. Ebon, did you say?
Yes.
Thank you. Thanks. Guerra Vasquez Gilberto.
He's here at Main, Judge, but he's gonna require a Spanish interpreter. I think my colleague already contacted the interpreting office.
Okay, great. So I'm
Yes,
gonna
we
put them
should
on.
have one shortly.
I'll put them on recall as soon as I see them come in. I'll call them back up. Thank you. Kirkabram Thomas.
Mr. Thomas, come on up.
All right, so Mr. Thomas, you've been arrested for 1 count of possession with intent to sell or deliver PVP. You're also being held no bond on case number 19-008378 CF10A. You have 2 no bond holds on that case, and that will be set in front of your division judge. Do we have a date for him?
Yes.
Oh, on October 22nd at 8:30 a.m., so you can address those matters. And then on count 4, driving on sidewalk. Okay, so the court does find probable cause exists for count 1 and would be imposing bond in the amount of $1,000 unless state or defense have
I'm not
anything they wish to say.
Nothing, I'm not requesting anything, Judge.
All right, thank you so much. Good luck, sir. You'll see your division judge tomorrow. Douglas Johnson.
Mr. Johnson's here at Main, Judge, approaching. Come on up, sir.
Thank you. Good morning, sir. Thanks for your patience. Sir, you've been arrested for 1 count of possession of THC as well as 1 count of reckless driving. Court does find probable cause exists and would be setting bond in the amount of $1,000 unless anyone has anything that they wish to address the court.
Judge, I'm gonna be requesting the court consider releasing Mr. Johnson, ROR, or on the alternative on pretrial release on this non-violent third-degree felony possession THC drug offense. My understanding, Judge, he's 30 years old. He is working at this time. He works for a company. He's been employed there for the same 8 months. ABC Supply, it's a roofing company where he's only making about $11 an hour. Unfortunately, from what he advised me, he's kind of going through a tough time. My understanding is, even though he has a place to reside at this moment, at the end of the month, he believes he's going to be homeless. Right now, really, there's not anybody that he can reach out to as far as financial help to post his monetary bond. My understanding, Judge, is he's not a convicted felon. So that's why we're asking for the court to consider our pretrial release on his behalf, Judge.
I'm fine with pretrial, Judge.
Okay. And pretrial, you're good with pretrial? Okay. So, sir, you're going to be released a pretrial release. You need to make sure that you report today if you get out early enough. If not, you must report within 24 hours of current time, okay?
Yes, ma'am.
All right. Good luck to you. Jesse, thank you. Jesse Bendros.
He's approaching, Judge, here at Main. Come on up, sir.
Thanks.
Good morning, y'all.
Good morning, sir. Mr. Bendros, you're currently being held on a no bond hold on case number 19-005517 CF10A. You're going to see your division judge tomorrow morning at 8:30 a.m. You have 2 additional counts, possession of cocaine as well as tampering with evidence. Court has reviewed the probable cause on those 2 counts, and the court does find probable cause exists. Any reason why the state shouldn't impose a $1,000 bond on counts 1 and count 2?
In light of the no bond hold, I wasn't going to request any kind of modification, Judge.
Same thing from this fence, Judge.
Okay, so it'll be set at 1,000 on count 1, 1,000 on count 2, and like I said, so you're going to see your division judge tomorrow morning. Good luck to you. Vaughn Carey, Vaughn Philip Carey.
North Broward, Judge.
Thank you. All right, Mr. Carey, you have been charged with 1 count of possession of cocaine, 1 count of DUI, 1 count of unlawful speed, and 1 count of possession of open container. Court has reviewed the probable cause affidavit. Court does find probable cause exists for the arrest. Any reason why the court shouldn't impose a $1,000 and $500 bond with no alcohol, no intoxicants?
Yes, Judge, I'm going to be asking the court to consider pretrial release for Mr. Carey. He has been a resident of South Florida for his entire life. He's been living at the same location for the last 3 years. Unfortunately, right now, he is not employed and does not have any savings to enable him to post a monetary bond However, I do not believe that he is a flight risk or a threat to the community. If the court would consider pretrial release with a condition that he not consume any alcohol or intoxicants, then that's what we're going to be requesting of the court.
I just need one moment to check his prior history.
Give us one moment, Mr. Carey.
Yes, ma'am.
I'm fine with pretrial with no alcohol, intoxicants, and random testing.
Okay, so state is agreeing to, on both counts?
Yes, Judge.
So pretrial release on counts 1 and count 2. It's going to be no alcohol, no intoxicants, random testing, sir. You understand?
Yes,
And
Your Honor.
what about driving?
Just asked that it be no driving without a valid license.
All right, so no driving without a valid license, okay?
Yes, Your Honor.
All right, good luck to you, sir.
All right.
Thank you.
You need to
All right, good
report
luck, man.
to pretrial today, okay? So make sure you report to them today.
If you get out in time,
And if not, within 24 hours.
yeah, he's going to have to come all the way down from Pompano to get there,
Okay.
Judge. He probably won't be out for another 5-6 hours anyway. First thing tomorrow morning, if you can't get there today, report in. First thing tomorrow morning, they open at 9 o'clock.
Yes, sir.
Okay.
All right, thank you. Good luck.
Thank you.
Thanks
All
so
right.
much. Are you here for a Spanish interpreter? Come on up. Can we call back up Guerra Vasquez?
Senor Guerra Vasquez? He's approaching, Judge Jermaine.
Thank you. And we do have the Spanish interpreter. Can you raise your right hand for me? Do you swear the translation you're about to give from English to Spanish, Spanish to English will be to the best of your ability?
Maria Salazar, certified court interpreter.
Wonderful, thank you. All right, good morning, Mr. Guerra Vasquez.
Señor Guerra Vázquez, buenos días.
Buenos días.
Good morning.
Sir, you have been charged with one count of fraud, misrepresentation.
Señor, le han acusado, el primer cargo es fraude con representación falsa.
One count of false identification given to a law enforcement officer.
El segundo cargo es que le dio una identificación falsa al oficial de la ley.
One count of possession of a unlawfully issued driver's license.
El tercer cargo, posesión de una licencia de conducir que había sido emitida ilegalmente.
One count of DUI.
Un cargo, el cuarto, de DUI, manejar bajo la influencia.
With property damage.
Con daño a la propiedad.
One count of DUI with an unlawful balance above a 1.5.
El quinto cargo sería manejar bajo la influencia con el alcohol de más de 1.5 de nivel de alcohol en la sangre.
One count of resisting a law enforcement officer without violence.
El sexto cargo es resistir al oficial de la ley sin violencia.
One count of leaving the scene of an accident.
El séptimo es irse de la escena del incidente, perdón.
One count of operating without a valid driver's license.
El octavo es operar sin licencia válida, manejar un vehículo sin licencia válida.
And one count of failing to submit accident report.
Y el último cargo es que usted no presentó el reporte del accidente.
Court does find probable cause exists for your arrest, sir.
La corte encuentra causa probable para el arresto.
State, do you wish to be heard?
Va a hablar el señor fiscal.
Not at this time, Judge.
No tiene nada que decir en este momento.
Defense?
Y la defensa
Judge, just a phone order?
solamente está pidiendo a su abogado que le den una orden para que usted pueda hablar por teléfono.
Okay. All right, so the court's going to be setting bonds on count 1 as to $1,000, count 2, $100, count 3.
El primer cargo que le está poniendo la fianza, el primero es $1,000, el segundo 100.
I'm sorry, count 3, $1,000.
$1,000 en el tercero.
Count 4, $500.
500 en el cuarto.
Count 5, $1,000.
$1,000 en el quinto.
Count 6, $1,000.
$1,000 en el sexto.
Count 7, $100.
$100 en el séptimo.
Count 8, $100.
$100 en el octavo.
And count 9, $25.
Y $25 en el noveno cargo.
Also, sir, no alcohol or intoxicants.
También, señor, orden de no consumir ni alcohol ni intoxicantes.
Good luck to you and have a nice day.
Y que tenga buena suerte y que tenga bonito día.
Hanyugen? Oh, can you make an announcement actually just to see if there's anybody else who needs Spanish?
¿Alguien más que necesite la intérprete de español?
Not at Maine.
Not at Maine. How about Paul Rain? Looks like their lights are off. Conti?
No.
And North Broward.
We're good at North Broward, Your Honor.
Wonderful. Thank you all so much. Thank you, Madam Interpreter.
You're welcome.
All right, Hanigan? Sorry
Is
if
he
I'm
a president
mispronouncing
of Maine?
that. How do you pronounce your name, sir?
Honeygan.
Hanigan. Okay. Good morning,
Yeah, like
sir.
honey sweet, a little bit sweet.
All right, Hanigan. All right, you've been charged with 1 count of grand theft auto. Court has reviewed the probable cause affidavit. I do find probable cause exists for your arrest, and I'd be setting bond at $1,000 unless somebody has something that they need the court to be aware of.
Judge, and speaking to Mr. Huggingham, earlier today, he's wishing the court consider releasing him on pretrial release. He's advising me he really much wants to dispute these allegations. Looking forward to his day in court. He will be coming back to court. He advised me right now he is going to school. He goes to Florida Career College. He's been doing that for the past 6 months, but he's asking the court to consider releasing him under supervision.
One moment, Judge.
Sure. Just give us 1 moment, sir. Mr. Linder's looking up prior criminal history, if any.
Anything else? Mr. Tristan?
Unsuccessful? All right, so in July of this year, he was actually unsuccessful from pretrial release on another case, so court's going to be setting bond at the $1,000 amount. Good luck, sir. Thank you. Nicholas Capiola?
He's approaching, Judge.
Thank you. All right, Mr. Capiola, good morning, sir. You've been arrested for 1 count of burglary of an unoccupied conveyance as well as 1 count of petty theft. Court has reviewed the probable cause affidavit. I do find probable cause exists for the arrest. State?
I think pretrial has something.
Okay.
Your Honor, he's currently out on Nancy Matson pretrial services. He's currently out on pretrial for case number 1901187 CF10A for grand theft. We're requesting this pretrial is revoked. He was placed on pretrial. He was placed on pretrial October 2nd of this year, Your Honor.
All right, sir, so you're currently out on pretrial release on case number 1901187 CF10A for grand theft. Seeing that the court has found that probable cause does exist for the burglary of an unoccupied conveyance as well as petty theft for the allegations that are here today, court is going to be revoking your bond on that case. You will be given a date in front of your division judge so you can address any of those issues in front of that judge, but as for purposes of today, that bond will be revoked. On the burglary that's before me, State, do you have a recommendation as to bond amount?
Your Honor, State's requesting a $5,000 bond. Considering that Mr. Capiola was just placed on pretrial earlier this month for a theft-related matter and is already violated. Additionally, he has multiple priors for burglary, conveyance in 08, burglary dwelling in 04, attempted burglary structure. He's also been to state prison on numerous prior offenses.
Okay. Court's going to be, Mr. Romero?
Judge, unfortunately, Mr. Capiola is not in a financial position to post any sort of monetary bond. He gets disability. He's a veteran. He lives locally here in Fort Lauderdale with a roommate. He's been living at the same place for about 1 year. His share of the rent is approximately $300. Now, I do understand he was out on the case. He was out on pretrial. My understanding was standard. He's picked up a new law offense. I'm asking the court to consider imposing a level 1 pretrial. Holding Mr. Capiola no bond is the most severe sanction this court can impose. I'd ask the court to consider something less restrictive, such as level 1, so that he can be on the outside while he's fighting these allegations.
Okay, thank you, Mr. Romero. On the 19-011-872 CF10A, sir, you are going to be held no bond. However, like I said, you can address those issues in front of the division judge, and that division judge, he or she may decide to obviously change the conditions of that bond, but that's what this court is going to be doing at this time. As far as count 1, it's going to be a $5,000 bond. Count 2 will be a $750 bond. Good luck to you, sir. Peter Samuels.
No problem.
Thank you.
Your Honor, if I could be heard before the court makes a determination.
Sure. Good morning.
Your Honor, upon my review of the probable cause affidavit,
I saw the same thing.
I think the officer's intent was a felony petty theft as opposed to a grand theft.
Okay, so does court, do you need to make an amendment, or can I just make an amendment on
You
here?
can
I
write it
saw
on
the same
fi-
thing.
You can write down the findings now. It'll show in the system as a grand theft until the state makes a determination to file charges. Should we file it as a felony theft, then the change of charge, there'll be a change of charge KP is created, which will change it in the system.
Okay. So the court is going to find probable cause exists, sir, for felony petty theft, being that the amount was for $205 and there were 6 prior petty theft convictions, according to the probable cause affidavit.
The
What do
standard
you-
bond for felony theft is $750.
Okay. Mr. Reedy, any reason why the $750 shouldn't be imposed?
Yeah, he can't make a $750 bond, Judge. Mr. Samuels has been living here in South Florida for the last 17 years. Unfortunately, he does not have any family in the area that can help him post a bond. He does have an address where he can stay, so we'd be asking the court for pretrial release for Mr. Samuels.
Your Honor, I'm going to ask that the court keep the bond at $750, so that a more thorough bond hearing could be held in front of his assigned judge to determine how best to proceed. Mr. Samuels has a lengthy criminal history. His most recent offense, a 2017 burglary of a structure and grand theft. He was sentenced to just over 17 and a half months in prison as a habitual offender. He was released from state prison February 21st of this year.
Being the fact that he's been deemed a habitual offender and lengthy prior criminal history, court's going to impose a $750 bond. Good luck to you, sir. Have a nice day. Thank you. Jean Joseph. Hi, Mr. Joseph. How are you, sir?
I'm all right, ma'am.
All right, Mr. Joseph, you have been, you're currently being held, actually, no bond on case number 17-06630 CF10A, as well as case number 17-08014 CF10A. Both of these cases, you have a no bond hold, and you're going to see your division judge tomorrow morning at 8:30 a.m. You can address any situation or issues in front of that judge. As far as the case that's in front of me, I find probable cause does exist for the obstruction charge, and court is going to be imposing a $100 bond unless anybody wants me to consider something.
Nothing to add from the defense, Judge.
All right, good luck to you, Mr. Joseph. You'll see your division judge tomorrow morning. Daniel Brantley.
Come on up, Mr. Brantley. He's approaching Judge Maine.
Thank you. All right, good morning, Mr. Brantley. Sir, you have been charged with 1 count of aggravated assault with a deadly weapon without intent to kill, as well as 1 count of resisting an officer without violence. Court did review the probable cause affidavit. Court does find probable cause exists for the arrest. State, what is your recommendation?
One moment, Your Honor.
Sure.
Yes. Yes. Well, I just saw it on my report. Your Honor, I'm going to be requesting a $15,000 bond, pretrial release of the GPS monitor, no victim contact. First off, the court should be aware that Mr. Brantley was arrested for a battery last year. It was resolved. He was convicted of the offense January 23rd of this year. In that case, Mr. Brantley punched a woman in the chest in a parking lot. I can also advise the court that Mr. Brantley is a registered sex offender.
Okay, so as far as criminal history goes, you said this year he was convicted in January?
Yes.
What was the charge?
Battery.
Battery. All right, and what's the extent of other prior criminal history?
2007, failure to register as a sex offender, just over 76 months state prison. 06, lewd and lascivious molestation of an elderly or disabled adult and battery. Violation of probation, 8-year state prison.
Okay, Mr. Romero?
Judge, Mr. Brantley advised me he has no one to call to help post his monetary bond. He's homeless. My understanding, he does have a mailing address, which would be in Oakland Park, but he advised me no one can post his monetary bond, so I'm asking you to take that into consideration to determine reasonable release conditions for Mr. Brantley.
The victim, based on the probable cause affidavit, the victims allegedly, they didn't know the defendant, correct? It was, okay. All right. Mr. Brantley, the court has reviewed the probable cause affidavit. I do find the facts of the probable cause affidavit concerning for public safety purposes. Court's going to be imposing the $15,000 bond on count 1. And court does find probable cause exists for the resisting officer without violence as well. No victim contact. I understand that you don't know the victims in this case, but if for some reason you come across them or find something about them, please, you're being ordered right now to not contact them. That means no direct contact or indirect contact. And what other conditions were you asking for, Mr.
And I understand Mr. Romero advised the court that he is homeless.
Right.
But at this point, and I know you just asked a simple question. I'm requesting a GPS monitor, and I'm just making a record that I believe the safety concerns outweigh his current living condition. That's why I brought up the specific allegations that the battery he pled out to involved him attacking a woman in a parking lot. It's similar allegations in this case, Your Honor.
Okay. Based on that, court's going to be imposing a GPS monitor as well, sir. Good luck to you. Will pretrial meet with him in the jail? Okay. Okay. All right. Thank you. Good luck to you, sir. Sultan. And I apologize if I'm not pronouncing that correctly. I'm sorry, Sutton. I'm looking at this. Sorry, they're all handwriting, so.
Mr. Sutton's here.
Mr. Sutton. Hi, Mr. Sutton. Good morning, sir.
Good morning to you too.
All right, Mr. Sutton. Thank you. Mr. Sutton, you've been charged with 1 count of possession of a cocaine, 1 count of leaving the scene of an accident, 1 count of expired driver's license over 6 months, 1 count of careless driving, 1 count of possession of an open container, and 1 count of no proof of insurance. Court does find probable cause exists for the charges. Court would be imposing $1,000 bond unless there's something that you all believe the court should be considering.
Nothing at this time, Judge.
Okay?
For the state.
All right. Thank you so much. Good luck to you, sir. Mr. Schnitzerling?
He refused to attend.
Refused?
And Your Honor, this matter was reset from the weekend. I spoke to Mr. Reedy. Mr. Schnitzerling is, he's already being held on a murder charge and another PBI. I think the other one is a robbery firearm. This was an ad charge. Mr. Schnitzerling was indicted by the grand jury, and they returned an additional charge of armed burglary. The state would be asking the court to make a finding of proof evident or presumption grade based on the original arrest warrant affidavit, which, though that charge is not contained in the affidavit, I believe the allegations would still satisfy the elements.
Okay. Mr. Reedy, are you appearing on his behalf?
Yeah, I don't know where he is, Judge, but I don't have any argument to make in light of the fact that he has a no bond hold on count one. We'd defer any argument about proof evident presumption great until such time as he can appear in front of his division judge. I was just kind of hoping he would be there so I could invoke his Fifth Amendment right to remain silent again, which I think I did when he was magistrated on the murder charge. So I'm just putting the state and all law enforcement agencies on notice not to attempt to have any contact with Mr. Snitcherling without contacting his attorney first.
Okay. Yes, sir. So court is going to find proof evident presumption great. Is going to be a no bond hold, and Mr. Reedy, you have put that on the record. Do you need that?
And just, yes, please, Your Honor, just also for the record, I can advise the court and Mr. Reedy, the state has in its possession the public defender's written notice of defendant's indication of his right to remain silent.
Thank you. And this is that affidavit. Thank you. Javon Springer.
Medical loan, Your Honor.
Thank you. All right, so this is medical reset. All right, so it looks like we just have 2 city cases left, and that is Mr. Hinton and Mr. Gerasimichuk.
Mr. Henson is still present?
When Mr. Shake came by, Mr. Linder, he had said it was time served. Does he usually come back or no?
You might be calling Mr. Mr. Shade's in touch with the city prosecutor, so I have no reason, I'm sure that's what they relayed to him, that would be the offer.
Does the city prosecutor normally?
No, that's why they usually get in touch with each other to get the offers relayed.
Okay.
So that Mr. Shade will advise the court.
Okay, because he
If I
said
might
it was.
interrupt, Judge, for 1 second,
Sure.
I've got the interpreter's office on the line. Do we need a Spanish interpreter for any cases that remain on the docket this morning?
No, we already made an
Okay,
announcement. They're all
right,
good.
that's what I had thought.
Okay, so Mr. Shate relayed that it was adjudication time served on all the cases, so, okay. Does anyone have a phone number for him to see if he's coming back? Give me 1 second, sir. I just want to see if your lawyer is planning on coming back or not, since you are represented.
Number?
Do you have the cell phone? Do you have it?
Yes, ma'am.
Okay, great.
954-478-5079. 5079.
All right, get a car. And I was doing that. I got it. Oh, you got it? I'm setting it up. New people in here.
Okay, he didn't answer, so that's normal for him not to come back?
If he already related the message to you, that's fine.
Okay. All right, so is this Mr. Hinton?
Yes.
Mr. Hinton, wonderful. Okay, sir, so your lawyer was here on your behalf earlier. You are set for a status tomorrow morning in front of your division judge at 9 o'clock. If you wish to appear in front of them with your lawyer present, you're more than welcome to. Bond is set at $500. Or you can resolve your case here today. And if you resolved your case here today, it would be an adjudication, court costs, time served, and no return to the location. What would you like to do?
I'd like the time served, ma'am.
Okay, raise your right hand for me, sir. Do you swear or affirm to tell the truth, whole truth, nothing but the truth, so help you God?
Yes, ma'am.
You can put your hand down for me. State your full name.
Gilbert Ray Hinton.
Okay, and how old are you, sir?
Pardon me?
How old are you?
53.
And how far did you go in school?
The 10th grade.
Are you currently under the influence of any alcohol, drugs, or medication that could affect the way you're thinking here today?
No, ma'am.
Have you ever been treated for a mental illness?
No, ma'am.
You understand you've been charged with 1 count of trespass, which is punishable by 364 days in the Broward County Jail, and the offer to resolve is an adjudication and court costs. Is that your understanding?
Yes, ma'am.
Has anyone promised you anything to enter into this plea?
No.
Has anyone forced you into entering into this plea?
What you said? No.
And you understand by entering into this plea, you're giving up certain constitutional rights, such as the right to remain silent, the right to have the state prove, beyond and to the exclusion of every reasonable doubt, your guilt in this case, your right to cross-examine, confront witnesses, your right to have a jury trial. Understanding all of this, do you still wish to go forward with this plea?
Yes, ma'am.
All right, you also understand that if you're not a United States citizen, entering into a plea today will subject you to deportation.
Yes, ma'am.
Knowing this, do you still wish to go forward with this plea?
Yes, ma'am.
And how do you wish to plead, sir? Guilty or no contest?
No contest.
I'm going to accept your no contest plea, and I'm going to sentence you to an adjudication court cost. Time served. You have 6 months to pay court costs. Good luck to you, sir, and have a nice day.
Okay, thank you.
Thank you. David Gerasimachuk?
No problem, Your Honor.
Thank you.
Welcome.
All right, sir, same situation. Your lawyer was here earlier. I can, if you'd like, you could appear in front of your division judge, which is set for tomorrow morning at 9:30 a.m. Bond is in the amount of $500, or you may resolve the case today to an adjudication, court cost, time served. What would you like to do?
I'd like to get it over with, Your Honor.
Okay, you understand when you say get it over with, it is going to be a conviction on your record. You understand that?
I do, but I don't even remember this thing. I got short-term memory loss from my injuries.
Okay. Well, what the allegations are, so you understand, is the allegations are that you were at 2051 North Federal Highway and that you were in possession of an alcoholic beverage in public. Do you wish to resolve the case?
Yes, ma'am.
Okay, raise your right hand for me, sir. Do you swear or affirm to tell the truth, whole truth, nothing but the truth, so help you God?
Yes.
You can put your hand down for me. State your full name.
David Thomas Gerasimchuk,
And how old are you, sir?
64.
How far did you go in school?
4 years in Alabama.
Currently under the influence of any alcohol, drugs, medication that could affect the way you're thinking here today.
No drugs, no alcohol, no nothing.
Okay, have you ever been treated for a mental illness?
No, ma'am.
Okay, and you understand you've been charged with 1 count of possession of an open container, and the offer to resolve the case is an adjudication, court costs, and time served. Is that your understanding?
Yes, ma'am.
Anyone forced you into entering into this plea?
Oh, you're talking?
Yeah,
You
is anyone making you do this?
No.
Okay, and you understand you're giving up certain constitutional rights, such as the right to have the state prove beyond and to the exclusion of every reasonable doubt your guilt in the case, right to have a trial, and so forth. You understand that?
Yes, ma'am.
Okay, and you also understand if you're not a United States citizen, entering into a plea today will subject you to deportation. Knowing all of that, do you still wish to go forward with this plea?
Yes, ma'am.
And how do you wish to plead, sir? Guilty or no contest?
I just want to plead to no guilty. I mean, guilty. No contest.
No contest. Okay, court's going to accept your no contest plea and is going to sentence you to an adjudication, court cost, time served. Good luck to you, sir. Make sure you pay your court costs within 6 months, okay?
Okay.
All right, have a nice day. All right, do we have anybody else that is at Maine, Paul Ryan, Conti, or North Broward?
North Brown's good, John.
Thank you. And it looks like everybody else is empty, so we are good until this afternoon. Thank you all.